The views expressed on this program are not necessarily those of WTJX, its board, staff, or underwriters.
On this episode of Comes with the Territory, we'll take a closer look at the case of an elderly St. Croix resident who sought expedited justice for his contaminated cistern, but now potentially faces a $44,000 legal bill. This after the VI Supreme Court ruled that a 2021 law granting trial preference for elderly plaintiffs was unconstitutional. Plaintiff attorney C. Jacob Gower will join us to discuss the case. Delegate to Congress Stacey Plaskett has raised concerns about the territory's management of federal funds and the risk of missing critical deadlines, while government agencies maintain they are on track to meet their obligations. We'll have more. Plus, a brief clip featuring Plaskett during an MSNBC interview has gone viral after being shared by Tesla CEO Elon Musk. We'll break down the conversation it's sparking and what it could mean for the Virgin Islands. The government of the Virgin Islands has officially canceled all contracts with Mont Ethos Pro Support after founder David Whitaker pleaded guilty to bribery and wire fraud. Now the company's new CEO is pushing back, arguing that Mont Ethos shouldn't be punished for Whitaker's actions. We'll have the details. And later, this week's panel joins the conversation to analyze these issues and more. Comes with the Territory starts now. Welcome to Comes with the Territory. I'm Jeanette Millen-Young. The Virgin Islands Supreme Court recently struck down a 2021 law that granted trial preference to the elderly and terminally ill, a law aimed at addressing the backlog of civil cases. This decision has profound implications for residents like Vincent Liger, who sought expedited justice after the 2021 refinery flaring incident on St. Croix, but now potentially faces a $44,000 legal bill. Here's more. On May 12, 2021, a large fire engulfed the top of the only operating flare at the Limetree Bay refinery, resulting in a release of oil droplets which traveled directly west and prompting the refinery to activate its incident command. Limetree Bay informed the Environmental Protection Agency that it was temporarily suspending production, and EPA officials said the repeated incidents at the refinery are unacceptable. The flare rainout incident impacted hundreds of St. Croix residents, including Vincent Liger, who claimed that the oil droplets coated the roof and cistern of his home. Seeking justice, Liger filed a lawsuit against the refinery in 2022, asking for compensation to clean his cistern. Liger later sought to expedite his case under a 2021 law that granted trial preference to elderly and terminally ill plaintiffs, an effort by the Virgin Islands legislature to address the backlog of civil cases. Passed in 2021, Act 8468 states that if a motion for preference for an elderly party is granted, the court shall set the matter for trial no more than 180 days from the date that the elderly party moved for preference. After the court granted Liger's motion, Limetree appealed the ruling, challenging the law's constitutionality and arguing that it violates the separation of powers doctrine.
Hey. The law person having business before the Supreme Court of the Virgin Islands, join and give attention. For this court is now in session.
During oral arguments before the VI Supreme Court in May, the justices criticized the 2021 law.
This law seems to be, it's going to create a disaster for the Superior Court judges.
Clearly, the legislature has the right to establish preferential treatment, but it does not have the right to go into the procedures in which the Superior Court establishes.
What this law has done is that it has gone into the scheduling of cases, it has gone into the discretion. As a matter of fact, it has invaded the judicial branch.
The justices issued a written ruling in August, ultimately agreeing with Lime Tree Bay that the 2021 law was unconstitutional. Lime Tree's attorneys have now filed a motion to compel Liger to pay their legal fees of approximately $44,000. Meanwhile, Liger still has no drinkable water from his cisterns. To delve deeper into the issue, we're now joined virtually by attorney C. Jacob Gower, who represents Vincent Liger. Welcome to Comes with the Territory, Attorney Gower.
Thank you for having me.
So let's begin by asking you, what has been his experience, Mr. Liger's experience, since this opinion has been rendered?
Well, since the opinion has been rendered, I think it's one of continued frustration. You know, as you addressed in the opening, the oil spill or the release was in May of 2021. I mean, it's been almost 3.5 years. And at some point, you know, a trial is necessary, right? You can't go forever without getting justice for this kind of conduct. And so, like, if I had to put it in one word, it's frustration.
So since the flaring incident, exactly how has this affected him?
Well, look, immediately after the incident, Mr. Liger is over 80 years old. And so you imagine he takes a ladder and he puts it out in front of his house. He crawls up onto his roof and he sees that he's got this polka dotted oil stain where you can see that there is hydrocarbons on his roof, and then takes his finger and wipes it and realizes, well, that's not supposed to be there, right? It's not sap, it's not motor oil, right? It doesn't belong there. And so since that period of time, he's been living with, you know, a roof that was covered in oil. And we knows what happens, right? The cistern is designed to catch rainwater that comes off your roof. And so any foreign contaminant that's on the roof makes its way into the cistern. So as a consequence of oil hitting the side of his house and hitting in his roof, he has been living, and his wife's been living with cistern water that has hydrocarbons in it. And so you can imagine what you use water for in your everyday life: bathing, washing, cooking. And, you know, and that's not to say that there's a drop of oil in every single time he turns on the faucet, but he is living a life, you know, with a source of water that is not necessarily clean, right? And we take it for granted many times. You turn on the water, it's supposed to be clean. He doesn't have that peace of mind.
Certainly sounds like a difficult situation. So how did you come to represent Mr. Liger with this situation, and why did you decide to take this case on?
Actually, I had gotten phone calls. I have clients all over the West End of St. Croix, and I've been representing clients for some time for problems on St. Croix. My phone was ringing off the hook with people that had been experiencing these problems. In fact, I started going door to door with people calling me, and I just said, "Tell me about your cistern situation." And I had so many people calling me that eventually I just went to the baseball park in Wim, and word spread, "Hey, there's an attorney at the baseball park." And one of the people that came up was Mr. Liger. And he and I had 2 or 3 conversations, and eventually he said, "Well, you know, I'd like you to be my lawyer."
Interesting. So let me ask you
So
this.
Mr. Liger is just a very impressive person.
So let me ask you this: how did you come to the understanding that both of you wanted to have this case expedited, and then you went on to use the current law that the justices decided was unconstitutional?
Mr. Liger has a very simple case. There are plenty of complicated cases in the Virgin Islands. Mr. Liger's is not a complicated case. Lime Tree came out, did an inspection, found the oil on his property. And so we knew we had something that was pretty straightforward, not a complicated case. I'm not going to rush headlong into trial as a plaintiff attorney if I can't prove my case. And I didn't need years and years and years to prove my case. And we thought it was important to be able to get into court and to have a jury of Mr. Liger's peers as soon as possible so that he would have compensation, or, if he won, would have compensation to be able to clean his cistern.
So you refer to this case as being very simple, but what was your reaction when the Virgin Islands Supreme Court struck down the law that that you would have used to get this case heard right away?
I wasn't terribly surprised. When we went to oral arguments, the writing was somewhat on the wall. We heard from a couple of the justices. They were not receptive to the law. And there was obviously concerns on their part that the legislature was stepping on their toes. And so when the opinion came out, it didn't come as a shock. It was something that I had expected since the oral arguments.
During the legislative hearings before the 2021 law was passed, senators discussed the need to address court backlogs, expedite the cases for the elderly. The Supreme Court referenced these remarks, particularly those of Senator Milton Potter, in their opinion, declaring the law unconstitutional. Let's listen to the brief clip from Senator Potter.
Clearly, the judiciary has the ultimate say as to how it chooses to manage its docket. And I guess if nothing else, this bill would send a message that the legislative branch is concerned that the docket is not moving as swiftly as it should.
Given that the Supreme Court used Senator Potter's remarks to justify declaring the law unconstitutional, what are your thoughts on their interpretation of the legislature's intent?
Well, I sympathize or understand why the court was, Senator Potter said we're sending a message. And so if I'm on the other side of that message, I wouldn't take it too lightly either. But as to the substance of what Senator Potter was getting at is, I don't think an expedited trial is just a matter of process. It's also a matter of substance. If you can't get a trial for a year, 2 years, 3 years, 5 years, 10 years, at some point it becomes substance. So look, we all get older, God spare life, but if you're over the age of 80 in the Virgin Islands and you're trying to move your case to expeditious resolution, with the backlog, it's going to be difficult. And that's not to say that you're not going to see justice in your lifetime, but with the backlog, it becomes very difficult. And at some point, process becomes substance if you don't get justice in your lifetime, or if your trial is 10 years from now.
Sure. So Mr. Liger decided to use this law, which it was law. He decided, let's go ahead and use it to our advantage. Next thing you know, it's struck down, and now Lime Tree is requesting legal fees. What are you thinking about? What are your thoughts about these fees that they're asking for, and how does this impact Mr. Liger?
Well, look, my reaction to it was, frankly, when I saw it, my jaw dropped when I saw it. This is not a fight that Mr. Liger took on lightly. He didn't put contamination on his own roof. He didn't ask for contamination. This is something that Lime Tree did. He didn't do it. And he's asked nothing more in this case than some measure of acceptance of responsibility from Lime Tree to make things right. And certainly asking for attorney's fees takes this case in the wrong direction. It does anything but making things right.
Exactly. And he still doesn't have drinking water from his cistern. Is that correct?
That is true. And look, and as long as this case remains in litigation, Lime Tree has expressed that even as this case progresses, that they may want to come test his cistern again. And so, you kind of have to preserve the evidence until Lime Tree says, they're done with any additional sampling.
So you're saying preserve the evidence. So that means that the cistern is still contaminated. He cannot use the cistern water at all. There's no cleanup, there's no relief. And you're saying preserve the evidence? I mean, it's there, correct?
It is there, and look, obviously, there's been a passage of time. I mean, I'm not going to argue with the fact that we've been through 3 hurricane seasons, and it rains and cisterns overflow. But there has not been, the emptying of the cistern, the scrubbing, the pressure washing, soap and water, and the refilling. I mean, that process has not happened, and that's. But also remember as well, like it's not an inexpensive process to do something like that. Mr. Liger is over the age of 80. Like most of the West End of St. Croix, he lives on a fixed income. And it's a tall ask to ask somebody that didn't, he didn't contaminate his own cistern. It's a tall ask to have somebody go out of pocket to fix somebody else's problem.
Understandable. So what can be done to ensure justice for Mr. Liger and other residents?
Well, look, there are, besides Mr. Liger's case, there is the class proceeding as well. And in that class is thousands and thousands of people that are situated just like Mr. Liger. And I know, and me and the other attorneys that are working on that case are confident that at the end of that proceeding, that some measure of justice is going to be dispensed. But also in Mr. Liger's case specifically, the train, the metaphorical train is back on the tracks. We're looking at a trial probably 16 to 18 months from now. That's if trial is set. That's something that Lime Tree has agreed to. But again, look, that's why he sought expedited consideration in the first instance. By the time trial happens in either the class case or this case, it's going to be 4.5, 5 years, maybe longer, between when the incident happened and when there's an ultimate resolution of these cases on the merits. And so, look, the time will come. There will be a trial one day. There will be a jury of, Crucian peers that will be sitting on that jury. But I'm very confident that at the end of this road is going to be something positive.
Attorney Gower, just with a couple more minutes, what message would you like to convey to the refinery, lawmakers, and the courts involved in this case?
Well, I don't have a message for the refinery. I'll let my speaking or my talking in court and in my court filings do that. But to the legislators, it's going to be tough going to eliminate the backlog, I believe, short of appointing some additional judges. And so, look, I know money is tight. Money is always tight. But I would encourage the legislature to get creative, to maybe find some way to be able to have additional people on the bench. To the judiciary, look, I practice in front of the judges every day, and I'm never going to criticize them for a very difficult job. But what I can do, what I'm happy to do, is that I would ask the judiciary to hold lawyers more accountable to move their cases. Many times, and I'm just as bad at it, asking for the extension, asking for 2 months when 6 weeks will do, asking for extensions on the 10-year-old docket. Hold our feet to the fire. And I can challenge the judiciary. Don't let some of this stuff drag out. If you've got a lawyer that's taking their sweet time, tell them no, get your case trial ready and let's get a move on.
Well, I thank you so much for the time that you spent explaining all of these issues before us with the Liger case, and I wish you well. Coming up,
thank you very much.
We'll hear from this week's panel, but first, let's look at the issues for discussion.
Mr. Speaker, the rebuilding efforts of the U.S. Virgin Islands will require an extraordinary level of coordination and cooperation between the local and federal governments.
That was Delegate to Congress Stacey Plaskett on the House floor months after Hurricanes Irma and Maria, calling for coordination and cooperation during the territory's disaster recovery. Now, more than 6 years later, Plaskett is calling for better communication and cooperation between her office and the Virgin Islands government as critical federal funding deadlines approach. In a recent letter to Governor Albert Bryan Jr., Plaskett raised concerns about the territory's management of federal disaster recovery funds. Plaskett's letter to the governor was apparently in response to a September 19th letter from the governor about rum cover-over Medicaid, and Treasury bond issues. In Plaskett's response, she stated that she wanted to discuss the pressing issue of federal funding deadlines. She wrote, "Through conversations with FEMA and public reporting, I have become aware of unresolved issues with critical infrastructure projects, information which should have been shared directly by the government of the Virgin Islands." Among the projects she flagged were the Harley Power Plant and Richmond Power Generation projects. She stressed that her office had not received the necessary information from the Bryan administration to assist in conversations with federal partners. But the Office of Disaster Recovery offered a different account. The ODR director said the territory is on track to meet FEMA's deadline, clarifying that projects only need to accept FEMA's fixed cost offers by the deadline, not be fully obligated.
These are all fixed cap grants. So in the FEMA process, the cost is offered to the territory and we have to accept it. And that's the deadline.
Williams-Octland further noted that the Harley and Richmond Power Generation projects were already accepted and just 6 projects remained to be finalized. Plaskett in her letter also mentioned ODR's $137 million contract with CH2M Hill, which has led to a lawsuit from Hill International. Plaskett stated prior to the publication of the lawsuit, "My staff contacted the Office of Disaster Recovery requesting an understanding of the decision rationale. This inquiry did not receive a response." But the ODR director said,
"I'm not sure who the inquiry went to, but I personally did not receive an inquiry. Once the case was filed, we had strict protocols on how we would speak officially on the matter, and I'm not aware of the request."
In another concern, Plaskett warned that the Virgin Islands State Historic Preservation Office might miss the deadline to spend federal hurricane recovery funds. But Historic Preservation Director Sean Krieger and the Department of Planning and Natural Resources confirmed that most of the $10 million had already been spent, with $600,000 remaining, which will be drawn down before the September 30th deadline. Plaskett closed her letter by reiterating the need for transparency, stating the people of the Virgin Islands need and deserve transparency. In other news about the delegate, Stacey Plaskett is drawing attention online after a video clip from her MSNBC interview last summer was shared by Tesla CEO Elon Musk on September 17th. The 18-second clip shows Plaskett discussing former President Donald Trump. Here's the moment in question.
And he needs to be stopped.
Although Plaskett immediately corrected herself, Musk's tweet stated, quote, "The Dems explicitly called for Trump to be shot, and now 2 people have answered that call," referring to 2 recent assassination attempts on Trump. The tweet has garnered over 27 million views. Plaskett, as the sole representative for the U.S. Virgin Islands in Congress, frequently appears on national media platforms. This viral clip raises questions about how these moments affect the territory's image. In 2021, Plaskett made history and gained significant media attention as the first non-voting delegate to serve as an impeachment manager in former President Trump's second impeachment trial, playing a key role in presenting evidence related to the January 6 Capitol riots.
He fanned the flame of violence, and it worked.
Plaskett has consistently highlighted her efforts to bring positive attention to the Virgin Islands on the national stage. Following the 2024 Democratic National Convention, she emphasized her mission, writing in a Facebook post, "Going to the convention is about letting decision makers know we are present and not to be forgotten. It's why I can text a news anchor to say you said Puerto Rico and forgot to say the Virgin Islands, and they then correct themselves on air. It's why I can plead with White House officials to grant the Virgin Islands the only waiver of cost share ever given to a locale. Not just being present, but using the time to advocate, advance, and champion our issues." As the Plaskett featured clip shared by Musk continues to circulate, many are watching to see how it might impact both Plaskett and the national perception of the Virgin Islands.
The government cancel a contract with someone who openly admitted and has pled guilty to defrauding the government of the Virgin Islands. I think that it would have been imprudent for the government of the Virgin Islands to continue to proceed doing business with that entity, giving what has come to light.
At a recent press briefing, Government House spokesman Richard Mota explained why the government canceled all of its contracts with Mount Ethos Pro Support. The abrupt decision came after news became public that Mount Ethos founder David Whitaker had pleaded guilty to federal charges of bribery and wire fraud. Curtis Jones, who took over Mount Ethos in April, is now publicly defending the company and pushing back against the government's decision to cancel its contracts.
I just didn't expect them to put their dislike for David above the safety of these contracts. Their contracts with us weren't generosity. They weren't them doing us favors. It was for us to be able to provide critical security in the Virgin Islands. And they decided that was less important than their dislike for David. Didn't see that coming.
Mount Ethos had been contracted to install hundreds of security cameras in St. Croix public schools under an agreement with the Department of Education, executed in February, according to Property and Procurement Commissioner Lisa Alejandro. Mount Ethos also had a contract with the Virgin Islands Police Department that was executed on October 10th, 2023, and a contract award with the Sports, Parks, and Recreation Department that was approved in March, though that contract was never finalized. All contracts were officially terminated on September 13, 2024, by the Department of Property and Procurement, according to Alejandro.
It certainly was not a happy Friday at 5:01 p.m. when Department of Property and Procurement sent those emails over. It puts us in a really awkward position. It puts the schools in an awkward position. It puts the parks and the public in an awkward position. And I would like to be able to pay my employees. I would like to be able to do this work and support the Virgin Islands. And now we can't. So what does that mean for Mount Ethos going forward? I don't know. It's very uncertain. And it's an incredibly difficult situation.
Former Property and Procurement Commissioner Anthony Thomas, who resigned from PMP in February of last year, is now Vice President of Mount Ethos. Thomas told the St. Thomas source that the contract cancellation was a significant setback for the Mount Ethos team, but the company remained committed to offering services wherever they could make a meaningful impact. Joining me on set to break down these issues are Clive Rivers, attorney at law, and Jamila Russell, host of the political radio show Just Jamila on WXTX AM 970. From our St. Croix studio, let's welcome attorney Key Walker, founder and managing attorney of the Walker Legal Group. Welcome to the show, everyone. Before we proceed to our main topics, I'd like to get your thoughts on the discussion I had earlier with attorney Gower regarding the Supreme Court's decision to strike down the 2021 law aimed at expediting trials for seniors and the terminally ill. Attorney Rivers, I'd like to start with you on your perspective on the court's decision and its implications for access to justice for vulnerable populations.
Well, there's no question that the legislature had good intentions in bringing about the law, mainly because we have this great backlog when it comes to cases, especially if you're dealing with the elderly. I mean, life is not infinite. And so they're thinking that somehow some people should get some preference. Now, I understand the Supreme Court's decision because the law is supposed to be what we call blind. And so it should be fair across the board. It should not favor the old over the young, the rich over the poor. And so I can understand what the court did or the court's rationale. But there has to be a mechanism, and I'm not quite sure what it is, because we do have an awful amount of backlogs. One school of thought might be we need to increase the number of judges on the bench. I am not quite sure if that will solve the problem, but it certainly should. It is without a doubt. I mean, I'm in private practice, and I get a lot of calls from clients with respect to their case. Some of it, they believe that somehow the attorneys are not the one who's moving the case. And sometimes something that could be true too.
If you heard Attorney Gower, he did make reference to attorneys not moving them.
Yes,
So you
yes,
can see why some
yes.
of the clients might feel that way. But
Yeah.
in your case, you don't think that that's the situation.
Well, it could be a combination of both, but certainly things need to happen.
Okay. And so, Attorney Walker, how do you see this ruling affecting future legislative efforts to address court backlogs and support for the elderly and the terminally ill?
I mean, the legislature can only do what it can do in light of, the checks and balances and the separation between the three branches of government. At the end of the day, the senators are elected, the judges are not, right? So I think to bring whatever relief they feel needs to be brought to their constituents, I imagine that the legislature will continue to try and make efforts to make sure that citizens are receiving justice in the system. So I don't think this is going to chill their efforts to try and bring some relief to the community with regard to the backlog of cases.
Jamila, should lawmakers bear some responsibility now that Mr. Liger relied on this law and is facing significant legal challenges?
Short answer, no. Senators are elected to represent the needs of the community. There is a backlog in the court system. You hear it annually when the court comes before the Senate for their budget call. The answer to that question is complex. There isn't any mechanism to hold judges accountable. We live in a system where there is supposed to be checks and balances, and the court system is the final arbiter. However, the people don't have a mechanism in which to hold judges accountable. So if a judge isn't doing their job, you can't file a petition to recall them because they're not elected. And so maybe we need to take a look at whether or not we need to have some judges, especially those on the Superior Court, become elected and have the Supreme Court of the Virgin Islands remain unappointed with the confirmation and advice of the Senate. But something has to be done. Short answer, the legislature is immune from being sued to collect for writing a law that's been ruled unconstitutional on merit.
I don't think that it wasn't the immunity question. Is like, should they bear some responsibility?
Well, if we hold that rationale, any other law that the legislature has written, if I take somebody to court in small claims, the legislature has written that I can take somebody to small claims. Does that mean that the person that I sued can now say the legislature should pay the debt because I won? I don't think that's reasonable to expect.
So, Attorney Rivers, what are your thoughts on this?
Remember, the case has not been tried on its merits. We're only talking about a motion that was defeated, whether or not the trial should be expedited. I think you heard Attorney Gower say that the trial would be in another 16 to 18 months. And so therefore, attorneys' fees, when it's not a determinative decision on the merits of the case.
So just because the attorneys are asking to be paid by Mr. Liger doesn't mean that Mr. Liger has to pay that.
No, it doesn't mean that.
Because the world is thinking, oh, this poor elderly person now has to pay $44,000.
No. I think what happened is they have now put forth what we call an application for attorney's fees because they have won on a motion for expedited hearing. However, the merits of the case has not been addressed, and that is not going to happen for another, according to Attorney Gower, another 16 to 18 months.
So you saw the legislature trying to bring some sort of relief. Is there a way for the court itself to come up with this relief?
Yes, there are ways. There are ways.
And you mentioned one, and I believe off air you mentioned the second one.
To be honest with you, I tend to believe that the court can start earlier. I was prior to coming to the Virgin Islands to practice, I practiced very briefly in Houston. And the court starts at 8 o'clock in the morning. And they move the dockets a little quicker, in some instances. I dare say that matters could be resolved much quicker, particularly in criminal cases. I see where We used to resolve cases before the cases get to arraignment. So there are mechanisms. It just requires a different way of doing things.
So perhaps because of this case, they may be considering on their own because they don't want the legislature to come back and try to figure out what other way to rush them, correct?
Well, I trust that they would work something out.
So I thank you so much for sharing your perspectives on this important issue. I'd like to move to another topic. Let's turn our attention to our first main topic, which is that Delegate Stacey Plaskett's recent call for government transparency on disaster recovery projects. Delegate Plaskett is concerned about federal funding deadlines and says that the local government isn't sharing critical information with her office. So now, do you think there is a communication gap between her and the governor's administration, Jamila?
It's been clear that there's been a communication gap between the office of the delegate to Congress and that of Government House, because we've had the delegate project a different message to that the administration has been projecting for a long time, as far as back as maybe 3-4 years ago, and as far back as the previous governor, where they're not on the same page. So I think that sometimes the office of the delegate to Congress is misconstrued, and the responsibilities thereof aren't aligning with what Congress intended that office to be.
Okay, well, so, Attorney Key Walker, now the delegate's concern is that she's there in Washington. If she doesn't have the information from the local government, how does she fully represent us? Do you think that this communication gap has any, you see any direction for it to be being solved, or is there going to be a continuous competition? And this shouldn't be, because they have different types of representation, correct?
I think there's a lot of history behind the issue that was raised in the delegate's letter. With regard to the federal funding, the information is available. I have a difficult time believing that she did not have access to it. In any event, there's also issues that have come up in the past where the administration's initiatives were not only just not supported by the delegate, but she kind of attacked them. So the VTOL transaction is an example. You know, in the midst of trying to obtain the funding from HUD, there's this entire article in one of our local media with her essentially saying, "Oh, this is not going to happen. This is not something that HUD finances." So there's an issue of trust there as well, because you want us to be completely forthcoming as an administration, but are you going to use that information to help us? Or will we have another incident like the VTOL transaction, where we're in the midst of trying to close a transaction and now it's all over the media, with our delegate not supporting and actually questioning and announcing that this transaction is not going to come to fruition. So I think there's some history behind that correspondence.
Attorney Clive Rivers, do you concur?
Well, I leave the politics to the politicians. And I am going to comment mostly on the legal issues.
Sure.
Because, to be honest with you, I don't get to follow up on much of the politics because I'm in my office dealing with legal issues. And so I am not, it seems to be a political thing that I'm not familiar
Chomping
with.
at the bit, I have Jamila Russell right behind you because she likes the political aspect of it. So I'm going to move on to Jamila, this political.
I do, and just to expound on something that Attorney Walker said, the delegate in her letter alluded to being provided information that these projects were in jeopardy. And when she made the statement regarding the HUD financing for the VTOL project, she also referenced her federal connections, giving her the information that these types of projects wouldn't go forward. So clearly her sources on the federal level aren't as solid as she would want us to believe that they are. But to go a step further, she's our delegate to Congress. Congress found it fit to have somebody represent the needs of the territory in Washington, D.C. The governor is elected by the people to represent and is the head of our government. And so she should be putting forth the agenda that's set by the representatives of the people, which is the governor and the legislature. And most times she has her own agenda, and it's not in line with that of the legislature nor of the governor. And so, and if she had people on the ground in the territory, they could follow the Senate hearings. The 34th legislature created the Committee on Disaster Recovery, and that committee has met in the 34th and the 35th, and they've called in the Office of Disaster Recovery, and we have spoken at length. We've had public hearings. The community has been kept abreast on the disaster-related projects. And if she was on the ground in the territory, focusing on the issues of the people of the territory, she would have the information.
But you're stating she had people on the ground, but she has offices on all 3 islands.
I think so.
You don't see them?
I don't know. Like I said, I work in the institution. I know that the Senate hearings are on TV and people follow TV. However, I'm old school politics. If you want to know what's going on, you send somebody into the Senate chambers. You want to know what is happening, and if there's a hearing of concern, you send somebody there so that they can talk to the senators, they can talk to the testifiers, and they can figure out what's going on with these projects. I can't say that I've seen anybody from her office in the chambers doing the work of the people of the Virgin Islands.
So, Attorney Walker, there are people on the ground, but are they paying attention? And according to Jamila, maybe they're not paying attention. Maybe they need more liaison, the Office of the Congressman needs more liaisons on the ground. What are your thoughts?
Well, I can't speak for what the resources are of the delegate on the ground. However, with regards to her letter and the Office of Disaster Recovery, I think it was disappointing to read the statement that she doesn't have access to the information. I mean, the Office of Disaster Recovery is constantly before the legislature. They have one of the most active and engaging websites of all the government agencies. With regards to the recent contract that she also made reference to, the award of the contract to CH2M, the ODR had industry days to make sure that everyone in the industry was aware of exactly what was going on. And the public statement about that lawsuit being filed and kind of suggesting that there was something wrong with the process without picking up the phone and at least asking questions of Director Williams Octolin, just left a bad taste in my mouth. I just feel that the integrity of our disaster recovery process is so important that it should be above politics. And this is a small community. We see each other every time. Just pick up the phone and ask a question if you're unsure about something. And I think that's how we should proceed, and we should be unified in our efforts, especially when we're in DC. But while I'm speaking, I do want to announce that ODR just issued a press statement confirming that they've met the September 30th deadline ahead of schedule. So I just want to congratulate them. The deadlines for all of those projects have been met, and I think we need to give congratulations to the ODR.
So let's move on to another topic. Now, let's shift our focus to another matter involving Delegate Plaskett that has people talking. Recently, a clip from one of her interviews went viral after being shared by Tesla CEO Elon Musk, sparking widespread attention. Let's look at the 18-second clip again.
Having Trump not only have had the codes, but now having the classified information for Americans and being able to put that out and share it in his resort with anyone and everyone who comes through should be terrifying to all Americans, and he needs to be stopped.
So, Attorney Rivers, what do you think about how Delegate Plaskett's slip has been amplified on social media by figures like Elon Musk? I know you don't like to talk about the political aspect of it, but now it's a social aspect and the public perception.
Well, Elon Musk controls a large media conglomerate. In fact, and Elon Musk is one of those individuals who was born into wealth and has maximized. In fact, if you were to Google his name and ask the question, where is Elon Musk from? He says Pretoria. Now, I know that there's no such a country as Pretoria. That's actually a city in South Africa. Now, so Elon Musk got his wealth from South Africa. Who knows whether it's blood diamond wealth, whether it's whatever it is. But he has control a lot of news media, communication. It's clear that, in my opinion, when I saw the clip, it seems to me that it was a slip of the tongue, and not something that should have been as maximized or put any particular attention to. But I think it's being skewed a certain way. In fact, there's no question, because I've heard former President Trump says that Elon Musk is one of his best friends. And so I think we should just, acknowledge it for what it is.
Take it was a slip. What it is.
It was a slip, but he's using it to maximize, to put former President Trump in the best light possible.
So Jamila, you're a media personality. How does this? What's your take on this? Because it just could have been an innocent slip, and yet it has been amplified because 27 million views at the last reading have viewed this clip. What are your thoughts?
Well, it's clear it was a slip of the tongue.
You see, just like that, right?
Just like I just did. But that being said, there's some things called a Freudian slip, which I hope it wasn't. But when you are a member of, you serve, and you serve as a non-voting delegate, I think that too much of the priority of our current delegate to Congress focuses heavily on the national political scene and does not align or represent the needs of the people of the territory. And at no time have I seen, or am I seeing enough of, rather, I should say, where the delegate is using her national platform to push forward the needs of our territory. We just got $188 million in rum cover over. When we had one rum company on St. Croix, we're getting in excess of $200 million. We've not been able to get the $13.25 made permanent on the national level. We have to remain and make friends on both sides. I think that has always been, our prior delegate, which is Delegate Donna Christensen. While she's a staunch Democrat, nobody can ever question her allegiance to the Democratic Party. She was able to work across the aisle with Republicans to push the needs of the territory forward.
So, Attorney Walker, how could this viral moment affect national perceptions of the Virgin Islands since Delegate Plaskett represents us in Congress?
I mean, I don't think it reflects poorly on her. I don't think it reflects poorly on the Virgin Islands. I mean, it was clearly a slip of the tongue. I think that that other party, the Republicans, are so desperate to spin anything that they're trying to, bring up an old video from last year, and somehow tie that to what has happened to Trump. My concern here is that now you're putting a target on our delegates' head, and I don't appreciate that, because she doesn't deserve it. And it's not warranted because it was a slip of the tongue. And that's really my concern here. I don't think this reflects poorly on us at all.
So let's move on to our final topic for today. The government has recently canceled all contracts with Ethos after former owner David Whitaker pleaded guilty to fraud and bribery. Meanwhile, new owner Curtis Jones is defending the company, emphasizing that Ethos continues to offer valuable services to the community. So was the government right in canceling its contracts with Ethos? This is for you, Attorney Clive Rivers, after Whitaker's conviction, or should the company be reconsidered under its new leadership?
My perspective is somewhat different. In fact, I took a public position with respect to not necessarily the contract itself, but how it impacts the criminal cases that Ethos was involved in. Because I am a criminal defense lawyer, and I believe that cases that has tainted, or evidence that has been tainted, those cases should be reviewed. And in fact, I've I believe that it's incumbent upon the Attorney General's office to review those cases and notify all defendants' counsels, what may have been the impact, because I believe in what we call fairness and due process. And if for any reason defendants were unaware of what input Mount Ethos may have had on some of these cases, they're entitled to they have their cases reviewed. And when necessary, conviction, remove, they have their second day. Now, with respect to the contract itself, whether or not new owners can go forward, that's left for another day. My main concern was, and still is, that defendants should be afforded the opportunity. Not only that, but you see, the Office of the Attorney General represents the people. And there's an old saying, or an old Supreme Court saying that says that the prosecutor is allowed to give hard blows, but they all must be fair. Not a single blow should be foul. And I believe that if Mount Ethos has anything to do with the collection of evidence, and the David Whitaker had anything to do with that.
Thank you for that. I want to go to Attorney Walker. Does Curtis Jones' new ownership of Mount Ethos mitigate previous ethical concerns, and should the government reconsider its decision?
I don't think there's, with regards to the Mount Ethos contract, I think it's clearly obvious that that contract needed to be terminated. It was, you know, it came about based on the fraud that Mr. Whitaker made upon the VIPD with those fake bug devices. Number one, to me, that's grounds enough for the cancellation of all of those contracts. What Curtis Jones is doing is trying to save his company. And what he's doing is now trying to, you know, divert everyone's attention and suggest that there's some issue with the government here. But the issue clearly is with the contract. And I agree with everything Attorney Rivers said. I have had 5 cases so far this year. I have a trial next month. All of a sudden, I have a phone dump in a case involving the AG's office where I've never had a phone dump ever from the AG's office in all the years that I've practiced criminal defense law. So I have some concerns as to where this is coming from. And I think that's what the focus should be. The contract is terminated. There's grounds for the termination. Let's make sure that this doesn't have a ripple effect in our community. And that's where our focus needs to be.
So, Ms. Russell, these officers of the court concur that these contracts should have been terminated, but what impact might terminating these contracts have on public safety, especially in the schools, the parks, et cetera?
I don't think Mount Ethos was the only person that could install a camera. And I don't think that the cost that we were paying for these cameras was, you know, the lowest cost possible that we could have had. I think that the contract was gotten into fraudulently, and I'm not the sister with ESQ behind my name, but I know that there is a legal terminology that, you know, fruit from the poisonous tree, that they throw all the evidence out. And so I think that the government of the Virgin Islands needed to terminate the contract. I don't think that we will find that we have a problem. I think there are other contractors that can install cameras, and that Mount Ethos was not the only person in the world that can do so, and we could do so from a company that is legitimate. The owners are legitimate, and they're not going to perpetrate a fraud on the people of our territory.
So there is yet one more question of ethics, and that is, does the involvement of the former Property and Procurement Commissioner becoming the vice president of Mount Ethos raise any conflict of interest question in your mind? Attorney Rivers?
I'm not sure. I'm not quite sure.
You'll punt it over to Attorney Walker?
I'll put it to
Attorney Walker, your thoughts on that? On
the former commissioner now being an executive with Mount Ethos?
Yes.
Is that your?
Yes, he's the executive vice president.
Without without more, I don't see anything improper there, so long as he did not use, any influence from that position or any information from his prior position in a nefarious way to support Manithos. I don't see an issue with that. I don't think we should be limiting people's opportunity for employment once they leave government.
So, Attorney Rivers, you said you represent clients that may have been impacted by Manithos. Do you think is a great body of or a great number of cases that could be impacted, or what are your thoughts on that?
Well, I don't know if it's a lot because it apparently it was a spread over 2 years, so it should not be a lot. But any amount is significant when you're talking about people's liberty. But just to follow up on the previous question, I note that
quickly,
even in the federal government, once you have secretaries of the various agencies, once they leave government, they end up with companies that turn around and do business for the government. I mean, I'm not quite sure if Mr. Thomas leaving to go work with a company, is a conflict unto itself. However, and I agree with Attorney Walker that once the ethics should be there, it should not be.
That is all the time that we have. This has been really a robust discussion. Thank you so much to the entire panel. That is all the show we have for you today. Be sure to tune in next Sunday at 1 p.m. for an all-new episode of Comes with the Territory. In the meantime, for your news updates, tune into the WTJX newsfeed on weekdays at 5 p.m. on 93.1 FM or by downloading WTJX, the WTJX app. I'm Jeanette Millen-Young. For all of us here at WTJX Channel 12, take care.